Innovation, imagination, wonder. These are just some of the words used to describe Dr. Harvey Passes. Dr. Passes explores interesting people and ideas that will stimulate you. He questions the people who develop, create, and employ novel concepts in business and everyday lives. He especially loves to speak with successful people. How did they do it? How can you do it too? So let's join Dr. Harvey Passes in his quest of wonder and curiosity as we watch Dr. Harvey Passes Presents.
Oh boy, sit down. That's right, sit down. We've got some interesting show today. You like watching all these terrific shows, these murder mystery shows, these police shows, these lawyer shows, and they're great. They're intriguing, they're compelling, they're engaging. How would you like to see the real McCoy or the real McWatson? How would you like to see the real thing? Today's show is going to be all about the criminal justice system right here in Nassau County. You're not going to get any of this silly stuff where in the last 2 seconds into the show we're going to figure out who done it. You're going to get the real stuff, and it's going to entail you. That's right, you and everyone else out there who lives, in this particular case, in Nassau County, because we're going to involve ourselves in the criminal justice system of Nassau County involving our own citizens and what happens. I thought it would be a terrific idea by asking my good friend and a frequent legal consultant to our show, Anthony Capetola, a very well-esteemed attorney, to come down here, and he brought with him an interesting guest who you're going to meet, and we're going to talk all about this. You're going to learn all about what goes on in our legal system. So, without further ado, I bring to you my good friend, Tony Capetola. Tony, it's great to see you again. Thanks very much. You are one busy man, so I thank you for taking the time and just giving into this need that I had. Terrific. Joy Watson, what a joy it is to finally meet you.
It's a pleasure to be here.
Thanks very much. Let me tell you a little bit also about Joy Watson. She's a very interesting person. Joy is an attorney. Joy is the principal law clerk to Justice Karen V. Murphy of the Nassau County Supreme Court. Prior to Joy's current position, she served as a Nassau County Assistant District Attorney for nearly 20 years. That sounds like a sentence. And you were under District Attorney Dennis Dillon. Your positions included Chief of the Sex Offense and Domestic Violence Bureau. Boy, oh boy, that must have been fun. And Deputy Chief of the Major Offense Bureau, where you were named Special Prosecutor. I remember this in the high-profile case of the people of the state of New York versus Elizabeth Grubman. She was the defendant convicted of a felony leaving the scene of an accident and assault after running down more than a dozen people outside an East End club. I remember that like it was yesterday. Amazing. I mean, it goes on and on. We can do the whole show reading all about you, but we're not going to do that.
Okay.
Instead, we're going to get right into the questions that I have. And Tony so graciously agreed to come down and be with you on this show so we can discuss this. This is going to be terrific. Everything you've always wanted to know all about the criminal justice system. How similar is the reality of what goes on in comparison to what you see like on CSI Miami, New York? They got this whole thing here, Law and Order. Is this accurate? Is this people see that and they figure that's the way it goes, or it's a little bit different?
Tony, may I?
Please go.
Okay. CSI, all of these CSI shows are probably the best friend to the criminal defense attorney and criminal defendant, because they set an expectation, they create an expectation that there's DNA evidence in every case, that there's a confession in every case, that every crime scene is pristine. Have you ever noticed on these shows it never rains outside? There's no contamination of the scene. And jurors watching the show come to expect that in each of the cases that they hear. And that's just not what happens. You know, you don't have a defense attorney whispering into the ear of a client 15 seconds later, the client coming back and saying, okay, I did it.
Well, you got to do that because you got the commercial coming up, and you.
Right, that's true. That's true. But it can make prosecuting cases, very difficult for prosecutors because of that.
Okay, so now we know that's just a lot of entertainment.
Exactly.
That's all it is.
Exactly.
It's just entertainment. The reality is this is pretty scary stuff. This is scary stuff in real life when you get involved with this and you say you're correct. The evidence is tampered with through natural or unnatural causes. There are problems with that. What's the difference between a misdemeanor and a felony?
Well,
Tony?
in our jurisdiction, a misdemeanor is a crime that's punishable by up to 1 year in jail.
Misdemeanor.
And felonies obviously would be punishable by more than 1 year in jail. Now, that varies in the various states across the country, but that's pretty much the general rule that one would look at.
I see. So it's really based upon what the punishment is.
Pretty much.
So, okay.
Pretty much. I mean,
Interesting.
the legislatures in each state determine what crime should be considered
Classified as.
Exactly.
I get you.
And over the course of years, the prosecutors and the defense attorneys then interpret the law, and there some exceptions may be created by case law, but generally, when it comes to defining what a statute means and whether it's a misdemeanor or a felony, the legislature decides that for the legislators that are elected by the electorate.
I see, okay. When we spoke about this show a while ago, and it took me a long time to nail you down to do this show because you're so busy, I said to you, I thought it would be really interesting for my viewer to see what goes on from beginning to end. Somebody commits a crime. You can make it whatever crime you want. Give my viewer an idea. A crime is committed. What are the steps that are involved till the very end, from either acquittal or sentencing? Can you begin with that? Let's get an idea.
Let me start from a defense lawyer's standpoint, and then
Fine.
I'm
And
going to
then
turn it over to
then the
Joy.
prosecutor will
That would
Sure.
be great.
Great.
I
Go
mean,
ahead.
typically, I mean, this past weekend I had, I think, 2 or 3 calls involving defendants that were arrested over the weekend. And
No name, please.
No names, no names. And their relatives would call and say they've been incarcerated for a certain crime was in Manhattan, County. So immediately we have to dispatch an attorney down to the arraignment court in Nassau County. It's at 99 Main Street, because that's an instant arrest. In other words, the defendant was arrested because a crime had just been convicted and he had just been arrested for it.
Convicted or committed?
Committed, excuse me.
Okay.
And he had just been arrested for it. And then there's an arraignment that takes place before a local district court judge, and that judge, in turn, hears the defendant's plea on the issue if it's a misdemeanor, that you could plead guilty or not guilty.
Maybe theft of a pen, as
Petty larceny.
opposed to I stabbed my landlord.
Sure.
Okay.
So typically, the theft of a pen, of course, the pens that you use, Harvey, are very valuable.
Grand larceny.
But that might be grand larceny. But typically, under $250 would be a petty larceny. You can enter a plea of not guilty. The judge would then fix bail.
Hold it a moment. You use
Sure.
the word, and I want to make sure that you can explain it briefly. What does arraignment mean?
It means that the defendant is brought before the court, and he has the opportunity to be confronted with the charges against him, and he enters his plea.
Guilty or not guilty?
Guilty or not guilty. And I would
Okay.
say that 99.9999 of the defendants are going to enter a plea of not guilty at that point to determine what their rights are at a later time.
Okay, good. So keep going. So now you're in the
We enter a
arraignment
plea of
court.
not guilty. The bail is determined by the arraigning judge. The prosecutor makes a recommendation as to what the bail should be in each given case. The defendant through his attorney is going to request no bail usually, but obviously that's not realistic in some of the more serious crimes. And the judge tries to balance the equities and fix a bail that's reasonable under the circumstances. And technically, it's supposed to guarantee the defendant's return to court, not to prejudge the defendant's guilt and fix a bail that's so onerous that's incapable of being posted.
Right.
You know, so that would be the first thing. And on a misdemeanor, then the case would go over to another part, which would be a trial part, and the defendant would thereafter, through his attorney, conference the case, perhaps enter a negotiated plea bargain where a sentence was agreed upon with the district attorney and the judge, or proceed with a trial. Differing from that would be a felony, and I think it's fairness to Joy, I'll let you take over, but we would then ask for, in that instance, a felony examination to determine whether there's sufficient evidence of the prosecution to hold the defendant for the action of the grand jury, and it then goes over to a higher court called, in Nassau County, the county court. And at that level, different things proceed, and the case is handled somewhat differently Matter of fact, materially differently than a misdemeanor case, because the grand jury's involved and the grand jury action's involved. And again, I'll let you go ahead, Ms. Prosecutor.
Take it.
The big difference between the misdemeanor and the felony is that in order for a felony case to proceed to trial, to actually get before a jury, you must go through the grand jury process.
What does that mean, the grand jury process, briefly?
That means that 24 citizens sit in a grand jury chamber, grand jury room, and they hear individual cases. And they're making a determination, not guilt or lack of guilt, but is there enough evidence for that case to proceed to a trial?
Are these jurors who are picked all the time, or is this a job? To be on the grand jury, is that a position, or do you get called up to go down and to say, hey, you got to be on the grand jury this week?
You get called up, yes, you get called up.
Oh, it's not a position?
Correct.
No. Okay, that's what I want to know.
Commissioner of Jurors of Nassau County
Is a position.
Issues a subpoena to the grand jurors to come in, or to a petit juror to come in, and his qualifications are then examined, and by lottery, technically, those persons are chosen to sit on either a regular jury panel or a grand jury panel.
And this changes all the time?
Every 4 weeks, monthly.
With your citizens?
Correct.
Okay, keep going, please.
Okay, well, what's interesting about the grand jury is that there's no judge present. The defendant, unless he or she is testifying, is not present.
Really?
There's no defense attorney present. It's the prosecution, a court reporter, a witness who comes in one at a time, because all of the proceedings are secret.
Oh.
And then the case is presented by the prosecution. The prosecution gives the charge, in other words, tells the grand jurors what the law is, and then subsequently leaves them to deliberate to come back with a decision on whether or not there's enough evidence.
Indict or don't indict?
Correct.
Indict
Correct.
then means what? What's the term indict mean? If they
That
say
means
we
that
don't-
there is sufficient evidence for the case to go to trial.
Okay, good. Okay.
But what's
going.
interesting, what's really interesting, and I think most people don't realize, is that everything that happens in the grand jury is taken down by a reporter. So that
You mean a court reporter or a newspaper reporter?
There might be newspaper reporters in the grand jury, but no, it's a court reporter. A stenographer takes everything down.
Okay.
A transcript is prepared.
Yes.
And that then is inspected by the judge, who can then say, was there sufficient evidence? Did the prosecution do the right thing?
Oh, so you're saying that even though a grand jury can indict, the judge might say,
Exactly.
I see this kind of technicality or whatever it might be, and that you can't do it.
Correct.
That's correct. And when they indict an individual, the term is that there's a true bill handed up. Where they're not indicted, then there's no true bill.
So true bill means we got you.
Well, not we got
As far
you,
as the
but
prosecutor's
we
concerned.
voted to indict you for the following charges, and then it's up to the prosecutor to actually take those charges, put them in the typewritten form of an indictment, and those are handed up to a judge, and the defendant is then notified to come before the judge to be rearraigned. Remember, he was arraigned earlier upon his initial arrest, but rearraigned on the indictment.
Okay.
Now, there are certain cases, we're getting very ahead of ourselves, but there are certain cases where defendants are directly indicted by grand juries in an initial arrest at the local level, and that's usually in organized crime cases or cases where there's been a lengthy investigation, and for some prosecutorial reason, the DA has decided that they want to go in that fashion and not tip the defendant off, and they'll just seek a direct indictment.
Okay, but that's not the guy stealing the pen. They're even
Absolutely
stealing your
not.
grandmother.
No.
This is a different story. Okay.
Okay, so
for obvious reasons. Keep going.
If you assume then there's an indictment, because that would be necessary, the next thing before you go to trial is you have to look at what evidence is the jury going to hear. And that's decided as a matter of law. If there's a confession, just because someone confesses doesn't mean the jury's going to hear it, because a judge has to make sure if there were Miranda warnings that should have been given, were those given properly.
What is a Miranda warning?
Miranda warning is your right against self-incrimination, your right to an attorney. You see on television that they give them all the time, at every moment, but that's not necessary. You have to be in custody and you have to be interrogated. It's a two-pronged test before the Miranda warnings are required.
You have to be in custody
Yes.
and interrogated. And before that happens, that's when the Miranda warning is given, or after?
Once you are in
think
custody, no, if you're in custody and they wish to question you,
Go ahead.
then you have to get your warnings.
Okay.
Before
okay.
questioning,
Right,
yes.
right. Can't question that. Okay. All right, so now you go through this. Keep going. Then
Okay.
what?
So then you'll have to also determine, were there any identification procedures? Was there a lineup? Was there a show up? Were those done properly? Or did you have 5 men and 1 woman, and the perpetrator was described as a woman? Was there and were there any problems with how the evidence was collected? In other words, did you have a warrant? Did you have exigent circumstances? So all of these hearings...
Who is the one who is looking to make sure that, what is it? It's like saying the T's are crossed and the I's are dotted, making sure that everything is done according to law. Who's doing this? The defendant's
Well, the defendant's attorney is going to examine...
Certainly not going to be the prosecutor. The prosecutor wants to prosecute.
Well, the prosecutor is going to seek to get an indictment and a conviction in every single case.
Correct.
But it's up to the defense attorney to interview the client, get whatever evidence is out there from the general public, and use his general common sense to see, oh, there is a confession in this case. Well, then in that case, were there Miranda warnings? When were they given? Typically, we have clients come into our office and they'll say, I was arrested and I never got my Miranda warnings. I said, well, did you give a confession? He said, no. He said, well, then it doesn't make any difference because Miranda warnings only are necessary to precede a confession and then the confession.
Self-incrimination.
Yeah.
Right.
But jurors, I got news for you, jurors, in this day and age, hear Miranda warnings and right to remain silent so frequently on TV that even if a confession is not given, jurors look at the whole totality of the picture. Pettit jurors who will try in a case, look at the whole totality of the picture that's presented to them, and they'll say, well, you know, this wasn't fair, or maybe it wasn't, the cop was overreaching. So you frequently like to bring that out in any event.
Really?
Absolutely.
Well, except that, and you might, but a judge, if a prosecutor is sharp enough, they should be objecting to that because it's not relevant. In other words, it isn't.
Right. There's no confession.
I agree with you 100%, but frequently it comes in as part of they used to use the expression raised yesterday, what's happening at the scene, and you'll say, what did you say to him, and what did he say to you, and the conversations will go on, and by the way, was he given his Miranda warnings, and the cop may say, no, I didn't, there was no statement taken, but still the juror has heard it.
He's heard it.
You
right, so it leaves a seed of doubt.
And as Joyce said, that the defense attorney was also going to be making a motion for the court to look at the sufficiency of the grand jury proceedings. Another thing that's done pre-trial to see if the instructions given to the grand jury by the prosecutor were correct.
Okay,
right?
you got
So
all these details. So you go ahead, let's say there's no indictment. What happens if the grand jury fails to indict? Is the case finished?
The case is finished. There are exceptions.
Okay.
There are exceptions if there is newly discovered evidence that could not have been found previously with due diligence. Then under certain specific circumstances, the case may be presented again. But by and large, if there's no indictment, if the grand jury fails to indict, that's it, the case is over.
Okay, there's a term, you hear this all the time, I love it. You can indict a ham sandwich, okay? How do you know? I mean, I'll say this again because you understand exactly what I'm saying, but they say, well, you know, the prosecutors, they can indict, the grand jury can indict anyone they want. They can even indict that ham sandwich over there. It doesn't matter. According to what you're telling me, that's not true. Am I wrong?
No, you're correct. That is not true.
It's not true.
First of all, and I want to go
That's
back
what I'm learning. I'm getting an education
right.
here.
You have to go back. I want to go back a little bit to what Tony
Go
said
ahead.
before, which was that in every case, the prosecutor wants a conviction, the prosecutor wants an indictment. You know, before the case gets to the grand jury, the investigation, as much as possible, has been completed, so that you're not just going in there willy-nilly. You know, the role of the prosecutor,
you did your homework.
Exactly, and also the role of the prosecutor is to be just. It's not necessarily to get any specific result. It's to make sure that whatever result the grand jury or the Pettit jury comes out with is the right and just result. That's not always going to be an indictment or a conviction, but you have to hope at least that sufficient investigation's been done up front so that if you're going into the grand jury, that is the right result, or you would not be seeking or asking for an indictment.
So you're putting all this effort and this information and this research into investigation, into this case which you want to get indicted and you believe it should be indicted. You haven't even gone to trial yet.
Right.
Now, why does it take so long then to go to trial?
Well, some of the things that I mentioned, the hearings that have to be completed to see about admissibility of evidence, takes time for the minutes of the grand jury proceeding to be transcribed. Witnesses have to be interviewed. The defense wants time to do some of their own investigation.
Now, this is
court backlog.
Right, court backlog, excuse me.
So in other words, so finally the grand jury says, okay, we find the defendant indicted on the counts of such and such. Then you go back to the judge, the arraigning judge, I guess. I don't know which.
Well, now you're going to a higher court.
Okay, and the judge is going to say, okay, these are, we found that you have an indictable offense and for doing X, Y, Z. Now, from that point on, does it take a long time to get to trial?
It depends what you
Usually.
define.
From that point
It
on.
depends
Right.
what you define as a long time.
Okay.
First of all,
A week, a month, a year?
well,
Usually
I'd say,
months, a matter of
months in Nassau County are administrative.
Because of the defendant, because besides the backlog and the administration and all that other kind of stuff, but I'm also have to assume now the prosecution did a lot of their work just to get him indicted. Now the defense attorney has to start doing his homework.
Sure.
Right.
That's one of the reasons why that's what I'm hearing. It takes so
Delay
much
does
time.
not benefit a prosecutor.
I could see that.
Memories fade, evidence can be, I don't want to say destroyed, but things can happen after the passage of time, whereas the defense needs that time to do work and also hopes on some level for a delay.
So now you get John Doe, who committed the crime of ABC, and he gets indicted. And then you go to court. And the prosecuting attorney brings up the fact that in the past we've found out that John Doe did ABC 13 times before in other states. And they're bringing this stuff up. A, can it be brought up if the person was acquitted of whatever those previous acts were? Can they be brought in and used as evidence to paint the picture that this person is capable of doing the crime, or you can't do it? It's not part of it.
No, you may not bring that up.
You can't bring it up.
You cannot bring it up for a number of reasons. Each case has to be decided on the merits of the case. You can't be deciding because someone's a bad person. If they did it once, they might do it again, what we would call a propensity to commit a crime. That's not allowed.
That won't work.
No.
Okay.
How-
Go ahead.
I'm sorry. However, if the person gets on the stand and therefore
They
his or her
open the door.
credibility, well, two things. Number one, if they open the door, then that's a different matter.
Okay.
If they say, I would never steal anything, then they have a prior record for stealing a pen. Well, then certainly it's relevant because
Gotcha.
they've opened the door. But also their credibility is at issue the minute they take the stand. And so what happens is before the trial, the defense attorney, the prosecution, and the judge will get together and make it. The judge will determine which prior convictions, if any, they can be, he or she can be questioned about.
It's exciting stuff, Tony. Very exciting. I mean, when you and I get together for dinner, I mean, you know, I just pull the string, and all of a sudden you start talking about all the cases and stuff. I mean, it's really interesting stuff. It's exciting stuff, and you got to have some kind of a brain to be able to think, to be an attorney involved in this, whether it's a defense or prosecutor, doesn't matter.
We're lawyers too.
This is very, very, very interesting stuff. So now, let's go to the next thing. So now John Doe confesses, I did it. And he confesses that he did it. I mean, why do you go to trial?
Well, you go to trial because the district attorney's office is, in this instance that we're using here, is not giving you a sufficient deal, so to speak.
Oh.
And you might not be left with any alternative. And the judge that you're before might say, well, I'm sorry, you know, if they're not going to reduce the charges, it's X amount of year in prison, so you have to go to trial. And the defendant may say, you know, I never really said that. The police tricked me into saying it and signing my name. They made promises that I would be able to go home if I just signed a piece of paper and everything would be forgotten about. I was under the influence of drugs or intoxicants when I made the statement, so I really don't know what I said. I was tricked. I wasn't given my Miranda warnings. I was flogged over the head with a baseball bat. You know, any one of those possibilities come out. So the voluntariness of the statement, whether or not the defendant in this case was influenced by drugs or intoxicants, the length of time he was in detention and interrogated, are issues that become germane to the question as to whether first the statement is going to be admitted in evidence against him, and second of all, if it is admitted in evidence, the jury, independent of the judge, can make its own finding that the statement that he gave, be it in oral or in writing, was truthful, accurate, and should be held against him for all the reasons I just discussed, and others.
So then, I think I know the answer anyway, but I'll voice it, the question. So someone is connected to a crime through DNA. Why would that person still want to go to trial? Because of what you just said?
It could be that, but that's an entirely different question altogether.
Please.
I mean, if for the sake of argument, it's alleged that a hair follicle was found at a crime scene, his defense may be, well, that's fine.
I'm bald.
I was at the crime scene many times prior to this, and the hair follicle was there on those occasions, obviously, because I had combed my hair in the bathroom, or I had I slept over to my friend's house. So that's where the hair follicle came from. It wasn't the day that the crime was committed, and on and on. You know, you can imagine how that can be played out. Now, if the defendant said, I never saw that person in my life, I never was in that house, then you have a different issue.
Then
and
you say,
then you
this
say,
is
well,
your follicle.
well, you don't say that, but obviously,
kidding.
I know you are. Obviously, you have a long ways to go with that argument.
Right,
Another way
right.
that it comes up quite often is that, let's say in a sex offense case, it could be, yes, I had intercourse with that person, but it was consensual. Once you
Exactly.
eliminate the defense that the person was there, okay, then another area of defense opens up.
Right. I can see that. So this is a very intricate chess game.
It really
Very
is.
intricate. I
Really
can
is.
see it. I can see it. You go here, and then bang, you get
Right.
something else, and you got to go here, and you got till you can finally get on the other side, get to home, wherever that is.
Self-defense is not necessarily eliminated as a defense just because someone's DNA is at the scene of a homicide. Sure, I was there. Sure, we had an altercation, but I did it in self-defense.
Right. This is fascinating stuff. Absolutely fascinating. What's the most common defenses to criminal charges?
It's either I wasn't there, I didn't do it, they're lying, in other words, they're making it up. What other defenses do you see most
I was
often,
going to make a
Tony?
joke, but it would probably, the other dude did it. I mean,
Right.
you know.
Somebody else did it?
Somebody
Sure.
else. I was there in the car, but I was asleep.
Wasn't me.
And I
Right.
didn't know what happened, or that my friend bought marijuana in the car, or that there was a stolen radio in the trunk. I was asleep. I didn't know anything about it, you know, and somebody else did it. And that's another area that we get into where you start talking about conflicts of interest, why one attorney cannot represent two defendants in one transaction, because then you're going to be stuck with a circumstance where there may be a conflict between the two defendants'
I don't mean to
positions.
cut you off. We got 2 minutes left.
Okay.
You believe how fast this goes?
Very quick. It was
great.
Amazing. Listen, I'm going to ask you one quick question, and then we're going to call it a day. Because would you come back again?
Absolutely.
And this is great
Be
stuff.
happy
This
to.
is great. And this, what about with children? Child abuse case. Okay, is it enough for a 10-year-old child to say that my mommy hit me, or my mommy didn't hit me, or whatever? Is the word of the child used as an indictable evidence?
Legally, yes.
Really?
Legally, a 10-year-old child is capable of taking an oath.
What about
There's
8?
a presumption.
Where does the number?
9.
9 is the cutoff?
Right. But nonetheless, an 8-year-old, and I've had it when I was prosecuting child abuse cases, I had 6, 7, 8-year-old children able to be sworn. The judge, though, would have to ask them individual questions about whether or not they could tell the truth, tell the difference between a
So
lie
the
and
judge
the
got to
truth.
figure out if he
Yes,
is a suitable
exactly.
witness to this.
Exactly.
In so many words. Yeah.
Very
Wow.
difficult cases, though. Very,
Wow.
very difficult to go with just the word of
Very
the child.
interesting. Let me tell you, you have to understand, doing root canal isn't easy. This is something else that's just as difficult. I mean, but this is fascinating stuff. Absolutely fascinating. And I got to tell you something, more fascinating than the TV show. More fascinating because the
It
TV show's
actually is.
contrived. This is the real McCoy. This is really, really terrific. Tony Capetola, I want to thank you very much for taking
pleasure.
time out from your active practice where you're in Williston Park.
I am.
And I thank you very much for taking the time because how busy you are is just terrific. And Joy M. Watson, thank you very much
My
for taking your
pleasure.
time
My
and
pleasure.
getting involved in the court system and everything and taking time to come down here. And I have you both on TV. There's no way of getting around it. I got the documents saying that you'll come back.
We will.
Okay, you
We'll
said
be here.
yes. Excellent. Loved having both of you here.
Great.
Just great guests. I learned a lot. That's the best compliment I love to give a guest. I learned something from you today.
Thank you.
It's the best compliment I can give you. I hope you learned something today. Fascinating, huh? Be careful. Don't commit any crimes. You don't want to get involved with these guys. You don't want that stuff. Root canals are much better. You save a tooth. Anyway, Dr. Pass is saying it's been a pleasure having this great show here today. It's been a pleasure being with you, and we got to go. And whatever you do, like these people do it with passion. Otherwise, what's the use? See you again next time.